So how do you set up an asset protection trust? A guy called the other day and asked to set up a trust. Then he asked, isn't a trust just a financial tool for the ultra wealthy? We asked, well, how much do you have to protect? And he said, well, I only have $6 million. In fact, we have clients who have from anywhere from $250,000 to a few billionaire clients. And a trust isn't just for the ultra wealthy. It's a powerful strategy for anybody looking to safeguard assets or reduce estate taxes and ensure their hard-earned wealth is preserved for yourself and for future generations. Yet many people are either unsure of how to create a trust or are unclear on its true effectiveness. So here's the truth. Setting up a trust doesn't have to be daunting. Its benefits extend to almost anybody with assets to protect, regardless of how wealthy they perceive themselves to be. So in this video, what we'll do is we'll break down how to set up a trust. We'll demystify the process beyond how trusts operate. We'll explore different types available, and then we'll show you how to harness the power of trusts to secure your financial future. And be sure to subscribe if you haven't already. So whether you're new to the concept or looking to refine your estate planning strategy, you'll find everything you need to get started. So here are a few questions we'll answer. What is a trust, so you know what one is? Why should you create a trust, so you'll be motivated to do it? How setting up a trust works, so you understand it. The cost of setting up a trust, so you know you can afford it. How to maintain your trust so you can keep it doing what you want it to do. Common types of trusts, notable trust subtypes, domestic or offshore. Which one protects you better? So what is a trust? A trust is simply a contract between a grantor, which could be you, also known as a settlor, and a trustee. During the setup of the trust, the grantor surrenders a select number of their assets to the trust, and the trustee will manage them for the benefit of a third party, the beneficiaries. And contrary to popular belief, trusts, like we said, are not just for the wealthy. People working in industries with high lawsuit risks, such as law, construction, and healthcare, often use them. And it's not just for the high rollers looking to secure valuable assets from predatory claimants. If you have a business or work in a profession with a high litigation risk, you have assets to protect. So here are some key terms used in trust setup. Some of the important terms associated with setting up a trust are as follows. Grantor settlor, that's the creator of the trust. This person calls us and has us form the trust, for example, alongside with a professional, and funds the trust with their assets. A trustee is a person or company that manages the trust and legally owns the assets held inside the trust. And trustees often are required to be licensed, they have insurance bonds, so that the funds they manage are insured. And beneficiary, the person, entity, or group of people who have some claim to the assets held in the trust. A decedent is a person who has died. The term is typically used in reference to a grantor. Property, any assets, items, or funds, real estate, or other possessions that are deposited into the trust. Professionals also refer to this as the trust corpus. So why should you create a trust? People set up trusts for various reasons, including asset protection. A properly established trust can be an excellent way to defend assets against creditors and legal action. So when you create a trust, you're essentially giving your assets to the trust and become property of the trust, that is the trustees and beneficiaries, because you no longer own the assets within the trust directly. It is much harder for creditors and lawyers to access those assets. So when properly drafted, you still have access to the trust assets, but your enemies at law do not. Somebody said, well, count me out because I don't want to lose control of my assets. That uneducated response is similar to how they catch monkeys in South America. You've probably heard if you put a shiny object or a nut inside of a bottle of the right size and the monkey reaches his hand in to grab the nut or the shiny thing and they tie the bottle to a tree, the monkey will reach his hand in, make a fist, and will be unable to pull it out. Inevitably, the monkey is so greedy that it refuses to let go and is snared by its captors. The same thing here with an uneducated business person who's so bent on hanging on instead of letting go of their assets into a trust. And keep in mind that trust is set up for their own benefit, that they end up losing everything in a lawsuit. So don't let that be you. Get educated and learn how asset protection trusts work and how safe they are. Estate planning. Certain trusts are not subject to the same tax burdens or probate fees as typical estate gifts. When you pass away and leave a trust behind, the beneficiaries can often receive more money than they would have if you had left the assets in your will. Avoiding probate. Probate happens when somebody dies and leaves the assets to be distributed, and the court reviews the will for authenticity or reviews the state's probate laws if somebody doesn't have a will and decides who to distribute the assets to. Now, probate can be super costly, as lawyers must review all of the relevant documents, and there's also court fees involved, and many states take probate fees. Placing the assets into a trust can help the beneficiaries avoid these legal fees. Additionally, trusts allow grantors to add specific conditions regarding how assets are distributed and used. Next is providing financial support to others. You can set up a trust to provide regular, for example, monthly, quarterly, etc., payments for certain purposes to cover college expenses, for example. Want your heirs to be well educated? Then have the trust pay for college and require them to have a master's degree or a doctorate degree before they can receive any additional funds out of the trust. Like Shaquille O'Neal told his children, before you can get daddy's cheese, referring to his money, you have to have 3 degrees. And this sort of trust also guarantees that your beneficiary can receive the support they need according to your instructions in the event of your death. Gaining privacy benefits. Many trusts, especially offshore trusts, can conceal assets from creditors and litigants. And this makes it far more difficult for them to claim that transfers were fraudulent. And that is unlike the probate process, which makes all of your assets a matter of public record, minimizing taxes. Trusts are also not subject to the same taxes as income and investment accounts. Leaving investment accounts and other wealth-generating assets in a trust can lower your overall tax burden. For example, we can add an AB provision to the trust, which doubles the amount that a husband and a wife can pass along to their children as state tax-free. Retaining Medicaid benefits. If your net worth or your income is too high, this can prevent you from receiving Medicaid benefits, and this can be particularly troublesome for grantors who require costly end-of-life care, like my mother did, which can drain their accounts that they plan to leave to family members. So establishing a trust, and this has to be established properly, by the way, that you form for your assets can make you eligible for Medicaid benefits. In fact, my mother, for example, we set up a living trust for her, but she refused to set up a Medicaid trust. So when she became incapacitated, we had to put her into a nursing home, and the home took $20,000 a month of her money and drained much of her savings. If she had not refused to set up this kind of trust when I recommend that she did, the government would have paid for much or all of that cost. How setting up a trust works. The exact process of setting up trust varies based on location, trust type, and trust goals. However, you'll always have to go through these 5 steps when creating a trust. Select your trust type, so you get the benefits that you want. Is it estate planning or asset protection? Choose a trustee. In fact, we do this for you when you set up an asset protection trust. With a living trust, the trustee is usually you. List all the assets you plan to deposit into the trust. Unless you put your assets into the trust is just a worthless pile of paper. So fund the trust. Next, hire an attorney or professional to create the trust document. In fact, our staff attorneys draft trusts according to your specifications. Next, you can bring the completed trust document to the bank that houses the trust fund and open a bank account. Choosing the right trust for your needs and setting it up can be complex, so it's important to hire a legal professional to help you navigate the legalese surrounding trust laws and provisions. And believe me, you don't know what you don't know, so make sure you have professional help. The cost of setting up a trust. Now, the bulk of your trust setup costs will go toward hiring a trust creation professional, and this expense really is well worth the cost. An experienced professional can quickly prepare all the legal documents for your trust, which would take weeks or even months for somebody without trust creation experience, and that person without experience would inevitably make mistakes that would defeat the purpose of the trust because a legal opponent could easily poke holes in it. So the cost to create a living trust varies depending on the experience of the one who drafts the trust. In addition, if your trust formation process is especially complex or it's simple, this can affect the trust setup fees. A living trust is typically in the $2,000 to $5,000 range. An asset protection trust, depending on where it's formed, is $12,000 to $30,000, depending on the type of trust that you need. So these numbers are as of this video, and naturally that'll change in the future. So how to maintain your trust. To keep your trust compliant and effective, it's really important, and I'll say essential, to fund it properly and fulfill all legal and tax obligations. So depending on the type of trust, taxation can vary. Some trusts are considered taxable entities, meaning the undistributed funds within the trust are subject to taxes, and then others transfer the tax burden to the settlor or to the beneficiary. So to navigate these complexities, always consult with a qualified tax advisor. They can help you understand the specific tax implications of your trust and ensure that you remain fully compliant while maximizing its benefits. You're typically not required to continually make deposits into the trust after creating it, but doing so is often a good idea. Any income that's not placed into the trust can't be protected by it during a lawsuit. So work with a financial advisor to determine your regular trust contributions. So when you consider tax implications for your trust, note that irrevocable and revocable trusts are taxed differently. When revocable trusts grow in value, typically that income is taxed to the grantor, since the trust is still one of the owned assets. Similarly, offshore irrevocable trusts typically pass the tax responsibility onto the grantor as well. Domestic irrevocable trusts, however, often have their own tax ID numbers and are taxed separately from the grantors. Offshore trusts also have a separate tax ID number, but they're taxed to the grantor. When the grantor files their own tax return, the irrevocable trust does not count against what they owe to the IRS typically. Instead, these trusts receive a deduction and the taxes fall to the trust beneficiaries. This often works out well, as beneficiaries commonly fall into lower tax brackets than grantors, and different types of trusts vary, so that's why it's important to get good licensed tax advice. Common types of trusts. Although there are many different trust specifications, let's discuss 4 different key types of trust funds: living trust, testamentary trust, irrevocable, and revocable trust. Living trust. A living trust is effective immediately after creation. People create this type of trust usually for estate planning purposes. That is, the living trust typically conveys their assets to designated heirs upon their passing. Thus, it avoids the expensive and time-consuming probate process. Testamentary trust. Now, a testamentary trust is typically established through your will and doesn't even become effective until after your death. The person who created it is called the testator, and people typically use this type of trust for estate planning purposes. Now, testamentary trust does not protect your assets while you're alive because it isn't even active until after you've passed. Irrevocable trust. Now, irrevocable trusts give ownership and control of all the trust assets inside the trust to the trustee. Now, once established, these trusts cannot be easily changed by the grantor, and people often use this type of trust as a method of asset protection because it separates the assets from the grantor, making said assets very difficult for creditors to access. Revocable trusts. Revocable trusts give grantors the ability to retain control over their assets within the trust, and a living trust is often a revocable type of trust. And they allow for changes to the trust itself. The terms trustee and beneficiaries can also be altered, and the terms of the trust as well as the beneficiaries can be altered over the life of the trust. Because the grantor maintains such power over the trust, revocable trusts are not effective in asset protection because the judge can say, hey, if you can change the beneficiary to somebody else, I order you to change the beneficiary to your opponent at law. And that's the reason why revocable trusts don't provide asset protection typically. Notable trust subtypes. In addition to those 4 main categories, there are KISS trusts: revocable living trusts, land trusts, title holding trusts, and irrevocable Medicaid protection trusts. Though these trusts fall within the main categories, their unique purposes are worth understanding. Revocable living trust. A revocable living trust is a popular type of trust for estate planning. These trusts have more before and after death advantages when compared to a testamentary trust or a will, which are other popular estate planning tools. The most notable benefit of a revocable trust is that it eliminates the need to go through the probate court processes. And this is a big deal. When a decedent passes their wealth onto another person through a will, a probate court will divvy up the assets and usually charge a hefty fee for doing so. A revocable living trust prevents this by serving as a substitute for the power of attorney. Essentially, the assets must be divided exactly as the trust specifies. And because these trusts are revocable, they can be changed at will by the grantor. This enables you to make adjustments based on shifting relationships with family members and other potential beneficiaries. This also solves many of the common issues with inheritances. However, you should know that if you cut out or exclude someone from the living trust as a beneficiary, they can still challenge the trust. A KISS trust. Now, KISS trusts are a popular option for anybody who wants to use the estate planning benefits of a trust but lacks the wealth typically associated with a grantor. These trusts don't cost nearly as much to set up as other trusts. These living trust arrangements can be started with a minimum investment of $1,000 or as little as $50 a month. In addition to the initial funding cost, there is a cost for general setup expenses, which is separate from that. Once funded, these trusts can grow exponentially in value, provided that you make regular contributions. This type of trust is usually set up to allow the recipient, typically a child or grandchild, to withdraw money based on a certain criterion. For example, if you listed a grandchild as a beneficiary, you could stipulate that the trust money is only to be used for higher education, home building, and wedding expenses. When your grandchild reaches the appropriate age to begin meeting these milestones, they can use the trust funds rather than drain their own bank accounts. So KISS trusts have tax benefits for both the settlor and the beneficiary. And once the money is deposited into the trust, it belongs to neither party. This ensures that the funds inside the trust won't prevent the beneficiary from qualifying for things like needs-based financial aid. Land trusts. In fact, we've set up thousands of land trusts, and its purpose is to hold real estate. Commercial properties, undeveloped land, personal residences can be placed within the land trust. Their primary benefit is confidentiality, privacy of ownership. They allow you to privately hold real estate. You can hold the property without listing yourself as the landowner in the public records. So this benefit is particularly valuable for those looking to avoid lawsuits, as the attorneys can scroll through the public records and file lawsuits against landowners for countless reasons. Title holding trusts. Now, title holding trusts are used to hold property titles, and typically these titles include personal property such as boats and cars and other expensive title assets. Like land trusts, you can use a title holding trust to keep your ownership of certain assets private. Irrevocable Medicaid protection trusts. Now, the cost of long-term care is far higher than many of us would like. For those who want to pass assets down to loved ones but need long-term care, things can get quite difficult. If your net worth is too high, you won't qualify for Medicaid benefits, which would otherwise pay for the long-term care. So many people who find themselves in this situation set up a Medicaid asset protection trust. And this trust, like other irrevocable trusts, separates your assets from ownership and can significantly lower your net worth. And if you set it up properly, you can use these trusts to leave money behind for friends and loved ones while retaining access to Medicaid benefits. So if you're considering setting up this sort of trust, it's really a good idea to do it sooner rather than later. Medicaid has a 5-year look-back period, meaning they can consider any assets deposited within the past 5 years when determining your benefit eligibility. Okay, now let's talk about offshore or domestic trusts. When you create a trust, you can establish it domestically or you can establish it offshore. And both options have respectable benefits regarding asset protection. However, you should understand both the advantages and disadvantages of each before you set up your trust. Domestic trust. Now, the first state that allowed domestic trusts was Alaska in 1997, and then Delaware and Rhode Island quickly followed suit later in 1997 and 1999, respectively. To date, there are only 17 states that have asset protection legislation, and the regulations vary greatly from one state to another. So if you're considering setting up a domestic asset protection trust, choose a state with the most beneficial laws. Now, a major drawback of a domestic asset protection trust is that it's under the body of laws of the U.S. government. Though powerful on many levels, these laws tend to be more creditor-friendly in the U.S., so you might think your assets are safe and secure under friendly Delaware legislation, but they can be placed in jeopardy if a lawsuit is mounted against you in another state like California, New York, Texas, Florida, or whatever. And it's not always easy to protect which side will ultimately win the battle between two equal but separate jurisdictions. And there you are, caught in the middle, trying to hold on to your assets any way you can. So you can go shopping state to state since you're not required to live in the state where you decide to set up your trust. Of course, what's beneficial for you may not be the case for another person. An asset protection trust must be customized to meet your needs and goals. So any asset planner who says otherwise is really giving you bad advice. Okay, now let's talk about offshore asset protection trust. An offshore asset protection trust puts your assets squarely under the guardianship of a sovereign country. A notable country is the Cook Islands, where we've set up more trusts than anybody in the world. Jurisdictions such as Cook Islands, Belize, and Nevis have settler-friendly laws to attract offshore investors and trust settlers. The primary benefit of an offshore trust is they do not have to follow U.S. court judgments. Many will require a new trial under their own laws, even for creditors who have already won in a U.S. court. So a new trial on foreign soil can be costly. And again, this also works for people in Australia, South Africa, UK, whatever. We set up trusts for people all over the world. Nonetheless, a new trial in foreign soil can be costly, time-consuming, and tedious. So a predatory plaintiff will often look for an easier mark rather than go through the trouble and expense of another trial against you. Setting up an effective trust with the help of asset protection planners. Setting up a trust can help you meet many major financial goals. So they're an excellent asset protection vehicle when set up properly, especially when you set one up offshore. However, if the thought of having your assets thousands of miles away makes you uncomfortable, especially at first, a domestic asset protection trust can offer ample asset protection under certain circumstances. And one popular alternative that we highly recommend is our trademarked trigger trust. Now, this is a domestic trust when the waters are calm. And then when the legal seas become stormy, the trustee can trigger the armor plating of an offshore trust. So no matter what type of trust that you choose to create, the key is harnessing the legal power of the trust and setting up as early as possible. And by doing so, you can preemptively protect your assets against lawsuits before one happens. Plus, you'll have the estate planning ready in the event of your passing. If you're planning on setting up a trust soon, we're glad to help. The trust establishment experts at Asset Protection Planners have been setting up domestic and offshore trusts for decades, and we can help you create a trust that provides you and your loved ones with the security and the peace of mind, the benefits that you need. So feel free to reach out for more free information at assetprotectionplanners.com. Fill out a free consultation form, and we'll see you next time. Subscribe for more. This is The Business Guy.